introduce themselves and get us started.
Thanks very much, Amy. Hi, everyone. Thanks for being here. I'm a partner at Keker. I've been here for about 8 years, and my practice from the beginning has focused on criminal defense. I was at the public defender's office prior to joining the firm, and now I do both the corporate investigations and appear in state court criminal cases. So it's a part of the practice I love and find fascinating. And today's presentation is aimed at helping you all who are navigating through either the government approaching you, or a situation in which you might want to reach out to the government regarding something that has happened at the company. So we'll walk you through the scenarios and how to respond and considerations when you're interacting with the government.
Hi, everybody. My name is Hillary Irvin. I'm an associate at Keker. I was formerly a federal prosecutor. I was an assistant United States attorney in Miami, and then also here in the Northern District of California in the San Francisco office. I've been at Keker for about 18 months, and the bulk of my practice is a mix of criminal and civil matters. On the criminal side, certainly government investigations, responding to them, responding to subpoena practices. And additionally, I also handle run-of-the-mill kind of like criminal defense issues, complex white-collar matters as well. And then on the civil side, I also do government investigations, if there are civil government investigations, as well as complex civil litigation that could potentially have an administrative nexus to it, or some sort of administrative or government-related hook. So I'm really excited to talk to you guys today about responding to process and what to do if you find yourself in a government investigation.
So let's go to the agenda. And I want to flag, we're going to start here with a little bit of a look at the current landscape, because as you all know, each new administration brings changes to enforcement priorities. And so we wanted to flag some of the changes that have been put in place so far, to the extent they tell us anything about what you might expect in the next few years as far as possible interactions with the government. We're looking at kind of early indicators of how the administration's priorities might affect the white collar and criminal enforcement landscape here. Then we'll move into what happens when the government calls you. How do you actually respond to the different types of outreach you might get? And Hillary is going to walk you through that process, looking at the threats and the risks involved, your rights, and our thoughts on how to best respond to mitigate the risks. And then I'll look at the flip side of the question. What happens when you may need to reach out to the government? What are the considerations you need to weigh there? What's the upside? What's the downside? How do you navigate working with the government once you've reached out and brought them into the picture? So let's start with the current landscape and this administration's shift in priorities, since there's been a number of big changes announced in the last 2 months. And we want to get a sense of what you might expect in the coming years. So Amy, next slide. To give you first some context, the trend has been consistently decreasing white-collar prosecutions. That's been the case for almost the last 2 decades. And if you look at the last Trump administration, the downward trend continued there. We see it in the monthly trends here as well, with the time period ending with January 2025. And one reason to think that trend will continue now is that there has been a lot of staffing changes, mostly downsizing agencies and different departments at the DOJ, which leads to fewer resources to prosecute these cases, and ultimately leads to fewer of these cases overall, is what we'd expect when you see less prosecutors with less resources in each of these departments. So let's go to the next slide. Now, the most significant signal that we've gotten from this administration about what they are going to enforce in the white collar space, we got 14 memoranda sent to DOJ employees from the new Attorney General. Each of those focused on identifying the priorities for this administration, and I listed some of those 14 memoranda priorities here, but the big picture is a lot of focus on foreign international activity in terms of the transnational organized crime, looking at protecting national security. So if we're looking at areas like the Bank Secrecy Act, the BSA, the Trump administration has indicated that, yes, they're very interested in the BSA, but more so when it implicates foreign actors. And so that will be certainly, we're already seeing certain prosecutions slowing down as this administration focuses on the more, with this global focus on cybercrime and other violations that they see as involving foreign actors. So as part of that, the administration has also indicated that it's going to shift away from the FCPA and the Foreign Agents Registration Act, which, despite their names, are really tools that have been used for regulating U.S. headquartered and U.S. listed corporations from bribing foreign officials to obtain or retain business. Trump administration has made very clear that is not going to be their priority here, despite the fact that the last Trump administration involved somewhere around 130 FCPA cases and total penalties in $13 billion. So they're looking at a slightly different approach this time around. Let's go to the next slide. A couple other things to flag briefly. The administration has also made very clear they're going to take a different approach to crypto regulations, and so focusing on making a more streamlined, creating a more streamlined approach to the cryptocurrency regulation. The criticism of the Biden administration had been that regulators regulated by enforcement rather than issuing prior guidance and rules. The newly established SEC Crypto Task Force issued a statement last month explaining that part of what they're going to do is issue this clear prior guidance to give more advance warning to actors in the cryptocurrency space about what they might expect. So we'll see how that plays out over the next year or two. Next slide, Amy. The other areas that the Trump administration has highlighted for continued enforcement is the cyber-related misconduct and protecting retail investors from bad actors in the emerging technology space. So this is looking at areas that involve AI and machine learning, scams through social media, hacking activities, and this Cyber and Emerging Technologies Unit, the CETU, they've explained will complement the work of the Crypto Task Force. So they're, at least as far as what we can gain from announcements that have been made, cyber enforcement is still going to be a big focus. And I know that's one of the presentations that you all have, maybe many of you have signed up for as well in this set of presentations. One focused specifically on the cyber space. Next slide, Amy. Now, one thing I wanted to flag here, because the FCA has been a pretty powerful tool for prosecutors over the past decade, False Claims Act cases have been a pretty big enforcement priority for and increasing in the last decade, with penalties that are constantly growing. And so I wanted to flag here that this is a specific area that the Trump administration has flagged as of particular interest to them, that the deputy AG at a conference last month gave a speech that was pretty directed at explaining that the FCA is going to be used fairly aggressively to achieve the governmental efficiency and root out waste, fraud, and abuse. And they, in that same presentation, the deputy AG spoke to particular interest in using the FCA with regard to folks in the actors in the healthcare space. The other sign we get that the Trump administration is very interested in the FCA as a tool for enforcing its priorities came fairly early, January 21st, one of the first executive orders that came out, titled the Ending Illegal Discrimination. One of the terms in that executive order included a provision requiring agencies to include terms in contracts where the contractual party agreed that its compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions. That is a precursor to building a case for a False Claims Act to contractual parties who receive federal funds and who the administration believes have violated anti-discrimination laws. That particular provision is under litigation. Last month, a district court enjoined the provision from being enforced. The Fourth Circuit just a couple of weeks ago stayed the preliminary injunction order. So this provision is currently in effect while it's being litigated. And what the court explained was that they'll be looking very closely at how it is enforced. Its constitutionality will depend on how this administration ends up enforcing it. So that'll be an area of interest over the next year as we see what happens in the court case and how the administration is actually using this tool that they flagged as on the very first day of the new administration's term. Next slide, Amy. So that was a very quick overview of what we see as important trends and signals for what to expect going forward. But now to get into the nuts and bolts of the actual, what do you do when the government reaches out to you? I'll turn it over to Hillary for that.
So we're going to talk about what you can do in the face of being served with some sort of process, such as a request for production of documents or a subpoena from the government. Can you go to the next slide? Great. So the first thing you'll want to do is assess the scope of what the threat could be by this request for production or by the issuance of a subpoena. The big picture thought you should have going into this is identifying who is the authority that is actually making the request. So subpoenas can be administrative in nature. They can be brought by a grand jury, for example, but they can also be issued by local, state, and federal governments. There's also the difference between criminal and civil subpoenas. So it could be from a prosecuting agency where there are criminal potential penalties, or it could be an agency that is looking for an investigation into actual conduct. But it really is, it depends on who or what the entity is that's making the request. The other thing that you'll want to think about in that same vein is what the government is investigating or who the government is investigating. It could be that the scope of the subpoena on its face shows that the company, meaning potentially you and your clients, are the subject of that subpoena. It could also be that there are executives within the company that they're investigating. But oftentimes there are administrative subpoenas also for third parties. So that could be a customer that you did business with or a supplier. Sometimes if you have the platform, it could be people who have used the platform. So really a customer that is an end user in a lot of ways. So that is going to be important in terms of assessing how you want to treat this and how you'll respond to the subpoena. Next, you're going to want to think about what the government is actually seeking. That on its face will help you kind of understand what the scope of the investigation may be and who or what the target of the investigation may be. And also, like I said, you'll want to think about how the government is making its request. So sometimes this could be in the form of an informal request for documents. It could also be an administrative subpoena issued by an administrative agency, but also a grand jury subpoena, and that could be criminal in nature. It could also potentially be civil in nature, depending on the entity. And in all of this, you'll want to keep in the back of your mind as you start deciding and making these assessments when the response is due. I find that thinking of this early on is very helpful in kind of working backwards. And it might also be that you want to seek an extension to respond to the subpoena because you need to make some decisions about the things that we just talked about, and potentially also want to engage outside counsel, and they may need time to get caught up. So in that case, you'll want to really keep your eye on the deadlines and show that you're being diligent by moving for extension early. Amy, the next slide, please. Thanks. You're also going to want to keep in mind the risks in responding. So the request being sought could implicate privileged or confidential information. It could also implicate trade secrets or items that are of competitive concern in your industries. In doing so, though, you should also be and keep in mind the obligation that you may have to respond to a subpoena. And if there are issues with responding and it was not comprehensive, or you decided to not provide information for a confidentiality or a trade secret reason, there is a risk of having administrative penalties because of the under response or lack of response. There are also potential criminal penalties. These three statutes here are federal criminal penalties associated with not responding properly to documents. So Section 1512 is related to withholding documents, and it makes it a crime to persuade another person to withhold a document or object to the proceedings related to the request for documents. The 1516 makes it a crime to influence or obstruct a federal auditor in the performance of their duties, obtaining these documents or obtaining the information. And Section 1519 makes it a crime to conceal or falsify documents or other tangible things to impede or obstruct a government investigation. Each of those penalties obviously require criminal intent, which is generally a high standard that can be difficult to prove when you're trying to assess group intent or intent from leaders or actors who may not be the people actually gathering the documents. But it is something that you should definitely be aware of when you're instructing potentially your employees to gather, collect documents at your direction. And this is definitely something that outside counsel, we at Keker, deal with a lot in terms of identifying the process by which this takes place, because you want to make sure that when you go through your process of collecting documents, that you are credible and that you are able to maintain credibility with the government throughout the subpoena response process. Next slide, please. You also should be aware that you have rights. Oftentimes, if you receive a government subpoena, it seems like the train might be already moving, but you have rights and you can do things to slow the train. So one thing that you should be aware of is that sometimes subpoenas ask for the ability to enter a premises or engage with employees or speak with employees, or might reference that, but they have no authority to require an interview or enter a premises on the basis of a subpoena. Additionally, if there's language that you have an obligation to produce forthwith, like immediately, you should be aware of what requirements are put onto you to make the production. And if there are concerns, if the request is broad or somewhat cumbersome, then you certainly have the ability to share with the government entity that, you know, the request is very broad, which we'll talk about a little bit later, but the request, even if it's not overly broad, may require some electronic discovery processes that can take a very long time. So you should be able to communicate with the government agency to some degree about that, so that they're aware of what the request requires of you, and so that you can continue maintaining credibility and a working relationship with whichever entity is the one that is doing the investigation. Additionally, a subpoena does not trump privileges that exist, so attorney-client privilege, additional privileges that may exist based on the documents if you've engaged people under the privilege, like experts or consultants. It also does not trump the Fifth Amendment right against self-incrimination, and that is a basis by which you can raise and object. And also there are FOIA protections that you should be aware of that may not apply to the scope of the subpoena, and those are bases by which you can consider not responding or limiting the response. Next slide, please. So how can one prepare the best response and make sure that you're on the right track when responding to these? First and foremost, unless there is some very, very serious defect in the process, you're going to want to accept service of the subpoena. It's usually not an area that is worth fighting, and it makes sense in most instances to accept service, unless, again, there's some serious defect in the service. The second thing you might want to consider is engaging outside counsel. We handle a lot of subpoena responses. That is something that we carefully think about and are able to do. And in large part, that is because subpoenas can engage other potential collateral related considerations that a company may have, such as in civil litigation. If there's ongoing civil litigation, you're going to want to be very thoughtful about the information that you provide to the government or government agency that could then be the basis for some other collateral consequence in this civil litigation context. Next, you're going to want to issue a litigation hold. So whatever processes you have in place for issuing those holds, you're going to want to follow through on those to make sure that there isn't a spoliation issue, meaning that you're not accused later of removing or obstructing or deleting any evidence. If you don't have a litigation hold process in place, that is also something that we can help you with. Litigation holds are very important to just make sure that even if you believe there is a basis by which to limit or fight the subpoena to some degree, that it isn't adversely considered against you, that the evidence wasn't kept in appropriate course of conduct or course of business. The next thing you should consider is contacting the issuing agency or the prosecutor. I received many, many calls from private defense attorneys or private attorneys who really wanted to just understand what were we actually looking for at the government. And I think that you can have good outcomes doing this. Sometimes, you know, government lawyers can be very busy. They have a lot of cases. They might cut a subpoena that is broader than what they're actually looking for. And if it's overly broad and you take it at face value, but maybe it's in the gray area where it's not so overly broad that you want to object, but it is broad such that it will create additional time or money to collect everything under the subpoena, there's definitely something that you can do to reach out to the government to see if there's some limiting aspects. And that really goes into the next point, which is negotiating the scope of the request. You should always be thinking about if the information requested is something that is, again, too broad or sensitive, that you want to reach out to the government agency and see where there is room to negotiate. Additionally, you're going to want to identify your custodians and start collecting documents. when you're doing this, you'll be keeping an eye on the date that you need to respond to the subpoena. And you'll also want to build out some sort of process that is defensible. So if you are responding to a more complicated subpoena that could create issues, you're going to want to document the process by which you did this collection and you identified the custodians, so that if it becomes an issue down the line, that you are able to defend the decisions that you made. And that, again, is something that we do often. You'll also want to notify the employees that may be approached in a government or administrative investigation. And that's because there are rules and issues about employees speaking on behalf of your company. So you're going to want to have your employees prepared so that if they are approached, that they are aware that they may be, whatever they say reflects on the company, and you'll want to make sure that they're aware of that and that you're able to prep them. Next slide.
This applies to former employees. It's important to think about who the government may be reaching out to separately. And if there are folks with whom the company has a good relationship, it may be worthwhile to reach out to the former employees so they know to come back to you if and when the government reaches out to them, so that there are less people speaking unprompted or in ways that are more risky for the company, outside of your scope or outside of your knowledge.
Good point. Next slide, please, Amy. Okay. So now we'll talk about what happens and what do you do if there is a request to interview you or an employee or a subpoena request for testimony. I've also seen recently that there are sometimes requests for written responses. So a request for a written statement under oath, that also might be the subject of a subpoena. And whenever you're going to be creating content that could be used against you in an investigation, you're going to want to be very thoughtful about what that is, because ideally, this is in the event of a subpoena, there's some administrative thing that they're investigating that is not related to you or your company. But in the event that there is, you should be thoughtful about, could that interview, the document that is content document, could that be the basis of an exhibit in a trial at a later date or some sort of administrative hearing? So you're going to want to really have your eye on that. Next slide, please, Amy. So just like in the event of a subpoena for documents, you're going to want to assess the threat here. Who's making the request? Who's the government investigating? Who is the government investigating? And how is the government making its request? That obviously will inform if it's a requirement to comply or if there is a voluntary aspect to the request. So an informal request, you may decide that if it's informal, you've assessed that it's not something that you want to engage in based on the strategy of the overall investigation, and you might want to deny that request. But in the event of an administrative subpoena, civil subpoena, a grand jury subpoena, or sometimes also if the FBI or some other investigating agency like the IRS is walking around knocking on doors, you're going to want you, meaning the company and your employees as well, to be prepared for that in deciding whether or not and what strategy to use when responding to that. The next slide, please. So again, there are risks certainly in responding to requests for content such as a statement or written or oral statement. So the request could cover something that is privileged or confidential, a trade secret, or some other competitive concern that you have. There also is the risk of an unprepared response. So you're going to want to be very, very thoughtful about preparing and reviewing what those responses are. If it is going to be an employee that is making some sort of statement to the government, you're going to want to prepare them in detail for questions that might be asked. You also want to be mindful not to present any false or misleading statements. So in that preparation, you're going to want to make sure that all facts communicated are true to the best of your knowledge, because you did some sort of diligence and you're able to represent that. 18 USC 1001 is making a false statement to the government. And again, there are intent requirements, so it has to be an intentionally or knowing false statement. But that is still something that is risky if there is some fact out there that could make that statement false. There have been cases on this, specifically the China Initiative cases, where there is a risk or has been a risk that if you make a false statement, that there could be criminal penalties. There's also lines of cases on omissions or failures to disclose certain information, not necessarily a knowing or intentional disclosure, but by omission, meaning that it could have been something that should have been conveyed and was the subject of the investigation, but for some reason it was not. So you're definitely going to want to have your eye on the target of the investigation, going back to the kind of core things you should be thinking about when you're responding to these, to see if even a fact that is not necessarily material to you may be material to the government, and you're going to want to have your eye on that as not to fail to provide some information that was in fact material. And specifically in the Craig case, that was actually a case that was related to the investigation into the Mueller investigation and related to whether a partner at Skadden had properly disclosed his work on behalf of the Ukrainian government and whether he tried to avoid having to register under the Foreign Agent Registration Act. And for example, if there's work that you've done and that is potentially the subject of the subpoena, again, even if it's not material to you potentially, it may be material to the government. So you're going to want to really engage on the strategy to respond to that because you don't want a potential risk of not appropriately disclosing facts. Next slide, please. Thank you. Again, when you're requesting or when the government is requesting testimony, you have rights there. So your employees can decline or defer or terminate government interviews for virtually any reason. Employees can also request counsel, and that can be either a personal counsel. It might be an employee who is situated that the company wants to obtain counsel for them. Additionally, there are protections such as attorney-client privilege protections, work product protections, and Fifth Amendment privileges that also trump these requests for testimony. Employees can also request immunity or Queen for a Day letters, and those are often also called Castigar letters. And those are statements, if you've made an assessment that you want to cooperate to some degree with the investigation, that you are getting immunity for the limited purpose by which you're going in and making a proffer to the government. So in this situation, the employee could go in, or some executive could be asked to go in, a board member potentially, but you're going to want to closely review the terms of the immunity letter, or if it's a proffer agreement, meaning you're agreeing to go proffer facts to the government, you're going to really want to be thoughtful about what the terms of that are. Generally, you're going to want to make sure that the terms include that this will not be used against you in any later proceeding. Additionally, you'll want to be mindful about if that is recorded. Generally, you don't want those statements to be recorded because that creates content that, again, could be used against you. So you're going to want to look at those terms of the proffer agreement quite critically, and obviously make sure that that is in writing and signed by you, both you and the government attorney.
One note I'll add here is just one development we've been following closely is the use of attorney proffers, which is, we go in all the time to have discussions with the government without the client. Those conversations are generally subject to certain protections, but last year, the prosecution actually took statements made in an attorney proffer in the Menendez trial and used them in the case in ways that were fairly unprecedented, which means this question of what exactly can be used from discussions with the government is a very is a changing one with every year, and we're following that very closely now.
Exactly. To Maya's point, these are pretty limited in terms of protection, and there's always a risk that the government could take that statement and then find other evidence that is not limited by that proffer and then use that against you. So if you're making such a proffer, you're going to want to be very, very thoughtful about what stage in the proceedings that you're in and what your bargaining position really is. Because the statements, depending on what the statement is, could also be the subject of cross-examination. So for example, if your employee or somebody makes a statement and later there's a trial or proceeding and they have a statement that they've been able to like have some sort of conclusive documentary recorded recollection on, that could be the subject of cross-examination material if the employee or person testifies inconsistently. And as we all know, facts fade with time. It could be something that is not intentionally inconsistent, but was a misremembered fact. And it would be, not ideal to have that same statement that you thought was given under immunity or under a queen for a day shield, and then it is used against you. So definitely think about when you're deciding to make some sort of proffer to the government, that it should be based on the strategy of either a cooperation, or you've assessed that for some reason it is in the best interest of the company, maybe because you're not the target of the investigation, for example. But that is definitely something that we advise our clients on in terms of whether or not to make such a statement. Can I have the next slide? And in this also, again, you're going to want to educate your employees on their rights by talking to them about what they can and cannot say in these proceedings or in the proffer proceedings, informal proceedings, a debrief of sorts with the government. And you're going to want to prepare them by practicing what that testimony or what the statements will be. Again, when doing that, you're going to want to clarify what role or what hat you are wearing in this investigation and decide who is the best person to represent the company on these statements. You should also certainly discuss in advance with the agency what topics are going to be covered and what documents are going to be reviewed, and make it very clear that you are not providing additional permissions to explore other topics that were not previously discussed. It is very rare, I would say, that if the interview or the proffer interview goes outside of the scope of what is agreed upon in advance, I'd say that most government attorneys, I think, would be reasonable, and you asking to not explore that in this proffer session, you'll want to take a break, you'll want to talk to the witness, you'll want to consult probably with outside counsel and set up potentially another time to do another proffer when you've had a chance to prepare the witness appropriately. Because the last thing you want is a non-prepared witness kind of riffing on what they think, and it wasn't something that you prepared them on because you didn't know would be something that came up. So this is the place where you should certainly meet the government and keep them to task in terms of what they said and what they represented to you in the first instance about what this proffer would be about. And to Maya's very good point, you can always recommend that instead of having a live fact witness or someone who could be a live fact witness make the proffer, that you could have the attorney make the proffer. And those often are less favored by the government because they know that there's been a lot of workshopping. But at the same time, if the content is the same, meaning you're going to be able to present the same factual underpinnings of whatever the potential witness would present, this is a good area to negotiate with the government and potentially explain to them that by making an attorney proffer that you can save resources and not run the risk of having to do multiple proffer sessions. So that's something you should have in your pocket to propose in lieu of having a lay witness or a employee of yours come in and make that proffer to the government. Next slide, please. So the next subject that we'll talk about are search warrants. Obviously, by the time a search warrant comes in, or if you're the target of a search warrant, these are sometimes moving and shifting things that happen. They can execute search warrants generally early in the morning, so not something that's on your radar. And it can be a very startling experience, certainly, to have, a group of agents come into a premises and execute a search warrant. So we'll definitely want to keep an eye on that. They're certainly less likely than receiving some sort of process, but often it's one of the tools in the government's box. So we'll want to talk about that. Can I have the next slide, please? Again, this is not, I'm sure, what anyone wants to have happening, right? Like, you don't want agents carrying boxes in and out of a residence or a business or some other sort of entity. And there are also potential public relations concerns with having such a public showing of an investigation. So this is an interesting depiction, certainly, of that, but this is more or less what that would look like. Can I have the next slide? So let's talk about the risks. The risks of a search warrant are varied and depends on what the target is of the search warrant. So there's risks of obstruction. So if there are deletions or moving or hiding of documents, that could occur by the kind of startling effect of having a search warrant. There's obviously potential business disruption if you are operating a business, or if the target of the investigation is a business front or business location. Having agents or law enforcement officers coming in and out could disrupt the business. There could be reputational and public relations harm. There's also the aspect to manage of an employee reaction. Employees could be panicked. They could potentially make statements to the agents or law enforcement personnel on the scene that could, again, be interpreted as a statement for the company. So you're going to want to be mindful of that. And there's also the potential exposure of privileged or confidential documents or trade secrets. Next slide, please. You'll certainly want to know your rights, especially when it comes to someone knocking on your door or opening it up and starting to search through things. So search warrants are limited on their face to the specific places that are set out in the search warrant. In a just kind of general teaching and practical point, search warrants comprise a few different parts. So there is the actual search warrant, and that's what's signed by the judge. And that will tell you generally in the lower part of it, what the actual target or offense of the search warrant that is being investigated. So it will tell you generally, a criminal search warrant will say what the statutes or rules that they are investigating that they believe to have been violated, and therefore are searching for some sort of evidence. Search warrants, unlike subpoenas, require generally probable cause or a higher cause standard. So by the time a search warrant is happening, there should be some cause that they're able to articulate. The kind of issue with that is that the search warrant cause is usually laid out in an affidavit that is not provided to the subject in some cases. So oftentimes affidavits can be filed under seal, and those could be sealed until the arrest of somebody or until a date certain that is laid out in the motion to seal. So in terms of obtaining the affidavit, you definitely should inquire about whether or not you can obtain a copy of it, and think about the reasons why if they tell you, no, you can't have a copy of the affidavit, why, and if there's some sort of basis by which you can obtain a copy of that affidavit. Certainly after the search warrant has been executed, you'll want to think about if there's no risk or no other government interest in keeping that information sealed, then it's certainly something that you'll want to ask for. Just thinking practically again about the kind of what's in the search warrant, there should also be a specific list of places that are within the scope of the search warrant to be searched. And that needs to be limited and articulated with particularity. So when that is stated, it needs to say, for example, an office and whose office it is, or an office that contains, XYZ documents. And you'll want to be mindful that the people on the scene doing the search are aware of that and are searching in the right places. And then the attachment or document after that is generally the items to be seized. And those are the things that can be taken from the scene when they are doing the search. There are special rules that apply to seizure of electronic evidence. So United States versus Comprehensive Drug Testing is a case that we at Keker handled, and that involved a search of electronics, computers, and under the prior Fourth Amendment standard and progeny formed following the Fourth Amendment, generally electronic evidence, when you were searching an electronic device such as a phone or a computer, the standard was that if you got into that device in a lawful way, that you would be able to seize, meaning capture, anything that was in plain view once you got to the lawful screen. So if your search is for something related to fraud, if they went into a device and found something unrelated to the fraud necessarily, but they got there to a lawful place, if they see something related to the fraud in that lawful place, they can technically seize that too. That was the previous rule. Following this case, comprehensive drug testing, the Ninth Circuit essentially held that here in the Ninth Circuit, the plain view analysis is kind of a farce when it comes to electronic evidence, because anything is really in plain view, and it's really difficult to make an assessment of whether or not something is immediately criminal or immediately unlawful by just looking at data. So under that same standard, there needs to be some sort of screening of the electronic device so that it is not that a free-for-all searching through an electronic device, but that the plain view standard can't extend to something that they see in device. So there are certainly limitations there that you should be aware of, and that is developing also in other circuits. Additionally, on the same slide, the agents must prepare an inventory and provide you a receipt of everything that they seized and every room that they searched. That should be very clear on its face. There shouldn't be any ambiguity in that. And you should be documenting everything that is on the receipt and inventory to make sure that there wasn't anything outside of the scope of the search warrant that was searched or was seized, because that is the basis by which you can challenge the search warrant. So there's certainly more to talk about here, but let's go to the next slide. So you'll want to prepare the best response possible before the agents arrive for when the agents arrive. So you should designate a point person who's on site. Generally, they may ask you to step outside of the premises while they do their search, but sometimes they will let you stay on the premises if it's not an officer safety or an agent safety issue. So you'll want that point person to be the one who identifies the lead agent that's on the scene, certainly request a copy of their ID, request their business card and their contact information. You're going to want the copy of that warrant that I talked about and the name of the prosecutor who is investigating the matter and their phone number as well. You should also contact outside counsel if you have an outside counsel relationship set up, and ask the agent to wait until that lawyer arrives so that all the processes in place are appropriate and that there is a legal observer of that. If they are not willing to do that because of some sort of external reason that they've identified, potentially officer or agent safety is a reason, you'll want to document that as well. So document. However you are communicating with them or whatever you're asking, you should certainly document if a request that you have has been denied, because again, that could also be the basis by which you challenge later the process by which that was given. You'll also want to send non-essential employees home to just limit the scope of people that could become witnesses and limit the scope of people that are there that the agents could try to talk to. You should advise your employees that they can, but are not required to speak to agents. And in that same vein, you should let them know that they could potentially also have a right to counsel at whatever requesting or conversation that agents attempt to have. Certainly, they could potentially talk to the agents, but they're not obligated to do so. And they should be aware that, again, any statements that they make could be imputed onto the company. So in a moment of panic or fear, they're going to still want to be very careful about what they say. Can I have the next slide? So during the search, you will not want to try to obstruct the agents or interfere with the search in any way whatsoever. And that is reason is their safety, but also your safety. Without knowing more about the target of the investigation, you'll want to just make sure that you're documenting the process, but not interfering. You should have that lead point person, though, monitor the search and take photos or videos. You should have them really recording all the places that the agents or officers are going into if they are able to stay on the scene. And in doing so, you'll want them to make that request for the necessary documents. And those are, again, the search warrant, and the inventory or receipt that is the basis for what they took. You'll also want to, if possible, object to the seizure of privileged records. And there are special rules that exist in the criminal context for searching locations that have attorneys' offices or counsel on the premises. So if that happens, if there is a reasonable basis to say that this is a place where there are potentially privileged records or are potentially have counsel or attorney in the place of the premises to be searched, generally that requires that the government have a filter team on site, and those should be non-interested people. So not the prosecuting attorney, but a team of non-interested people who are on site to make sure that there is filtering between any privileged records and the search. So if you have a reasonable basis for that, that's something you'll definitely want to raise. And it will also show that you're aware of your rights and that they need to be aware of your rights as well. You definitely should not consent to search beyond whatever is in the scope of the warrant, and do not volunteer additional records. Sometimes agents or officers are very, quite frankly, tricky about asking for consent and might do it in a casual way. And you'll want to be kind of on the offensive here and shut that down. And again, request the inventory, request the receipt, and those will be separate from the search warrant attachments or search warrant documents that you'll want as well.
I think, Hillary, because we have, I think, 7 minutes left, we may switch over to the flip side of the equation so we get a little time to cover it. Now that you all are experts on responding to search warrants, much more so than most folks who have people show up at their door. So let's move on to the corporation as cooperator or victim. When you decide you want to call the government, this is not the government showing up, knocking at your door. Thankfully, this is you as corporate counsel deciding it may be best for you to reach out to the government yourself. So let's talk about when you might do that and what you have to consider. Let's go to the next slide. So first things first, what's the potential wrongdoing? Is this a situation where you've discovered embezzlement of funds by employees? Is a situation of trade secret theft? How is the company involved? Who are the bad actors if there's something to report? Is it an external threat? Is it an employee? Is it an executive? Is the company a victim, a witness, someone who's implicated in the behavior? So what is the exposure for the company? And that's a very sort of big picture first set of questions. What's your positioning as the company regarding the conduct to be reported, if that's what you're going to do? There's the big picture questions of, well, if you're going to call the government, who exactly would you be calling? Is this a situation where you're bringing in the federal government, the FBI? Is this a regulatory matter? Are you bringing in the FDA? And really, most important of all, what does the company want to accomplish? Is a situation where you want the government's help in investigating a situation? Do you want the government's help in serving as a deterrent to misconduct? Do you want to get ahead of misconduct and limit liability for the company by getting ahead of it? So let's go to the next slide, because we'll look at the benefits of calling in the government. And the most important generally consideration when you are getting the government involved in potential misconduct at the company is it going to give you cooperation credit? Is it going to benefit you as a whole to raise this with the government before it becomes a bigger problem and then you're on the defensive? One note on this, since a lot of the topics of today we can't address without addressing the changing administration, is that, again, that how much cooperation credit you get is also affected by the administration and what the DOJ's policy is at any point. And so under the Biden administration, there was a very detailed memoranda on what was required to get cooperation credit under Biden's deputy AG. And the Trump administration has rescinded the policy, and while we don't have new guidance yet from the DOJ as far as what exactly will constitute cooperation credit, we have the Rosenstein memo from the first Trump administration as a guide. Under that memo, or under that policy, prosecutors were authorized to give partial cooperation credit to companies that made, quote, reasonable efforts to cooperate with the DOJ. That is a somewhat lower bar than under the Biden administration, which set up a long list of information that the potential cooperator needed to provide regarding, all the information regarding all persons involved in the corporate misconduct. The guidance now appears to be requiring slightly less information, and so it may be easier to get cooperation credit under this administration. But that's the first thing to consider. Are you limiting liability by reaching out, or are you creating additional risks by reaching out? If you are the one who initiates the investigation, you as the company retain a slightly greater measure of control than you would if you are just reacting to the government coming in. Obviously, having the government come in with the full power of the government is a greater deterrent effect. If you have a big trade secret issue, maybe you want to send that message to employees and to anyone who might misappropriate your trade secrets. And of course, you get the benefits of bringing the government in and having access to the greater investigative tools. They can seize computers, phones from third parties in ways that you as the company cannot. And you get to play a role in weighing in on restitution, what is appropriate. Since we're getting close to the end, I think I will just do, Amy, let's do the next slide to talk about the risks. So you can just have that big picture in mind, but we'll skip the rest. One thing to note, when you call in the government, I said you gain some measure of control in the sense that you are the one who can start framing the narrative for what happened. But of course, you do not retain control over a government's investigation. You don't know the paths they might take. You cannot direct the paths they will take. And if the government is going to do a multi-year long investigation, then you are along for that ride. When you invite the government in, you're also inviting in their investigators who may cause a lot of disruption in your workplace. If you have parallel civil lawsuits that you're pursuing at the same time, a court may stay that civil lawsuit because of Fifth Amendment issues, because now there's a criminal case. And of course, the increased press, publicity, time, expense, and distraction of having the government in your business, interviewing your employees, making statements of their own that draw attention to your company. These are all things to consider when you are inviting the government in. So we'll skip the rest, and I am very sorry we did not leave you time with questions, but we're very glad you joined us today, and thank you all so much for being here.